Good morning, Chair Hesney. Everyone has been admitted from the waiting room, and we are now recording.
Good morning, everyone. Before we get started, even if you are able to hear me now, in order to ensure that you have good audio quality in the meeting, please go, if you're in the Zoom application, go to the bottom right, and there is a language button, or it may say interpretation. Please either select English or Spanish, whichever your preferred audio is. This will ensure you're able to hear the meeting well throughout the proceedings, and I will give a moment to have that message relayed in Spanish as well.
Buenos días, gracias por acompañarnos. Good morning. Dealing with a little bit of technical difficulties this morning. Buenos días y gracias por acompañarnos hoy. Vamos a tener interpretación en nuestra junta si usted nos está acompañando sobre Zoom. Hacia el abajo de su pantalla, por favor, encuentre un glóbulo que dice interpretación. Haga clic allí y escoja español o inglés. Aunque vaya a escuchar la junta en inglés, por favor, haga esa selección que va a asegurar que puedan escucharnos. Gracias.
Thank you, Santiago. Okay, this meeting is now called to order. I will first go through the roll. Board Member Broad?
Here.
Board Member Flores? Board Member Hall is not able to join us today. Board Member Lightstone?
Here.
Wonderful. Okay. Also present today is a variety of staff for the ALRB, our Executive Secretary, Mr. Santiago Avila Gomez, who is going to provide technical support. We will start today with the open session portion of the meeting. We have several presentations, and members of the public will be able to provide public comment immediately after those presentations, and we will have general public comment at the end of the majority of the business items today prior to the board going into closed session. We do have limited capabilities for managing participation during the meeting, so we do ask that you keep your device on mute if you are not speaking, and when we call on you, please go off mute. These instructions are also available on the ALRB's website at alrb.ca.gov on the meeting agenda. If you wish to make a comment, please either send an email, use the raise hand feature in the Zoom application, or send a message. If you have an organization, please send your name and organization if applicable. And please do not include any substantive messages in the Zoom chat when making comment. Okay, and we'll give a refresher of those during the public comment period as well. All right, the first agenda item is to approve the meeting minutes for our most recent meeting on September 27th, 2023. May I have a motion?
So moved.
Board Member Broad moves. May I have a second?
Second.
Board Member Flores seconds. All those in favor say aye.
Aye.
Wonderful, thank you. The minutes have been approved. Our next agenda item is the chair's report. As noted, we will have a presentation from our general counsel on the restructuring of the regions. Briefly ahead of that presentation, I do want to take a moment to acknowledge that this coming Monday is Indigenous Peoples Day. I want to give a land acknowledgement in honor of this event. This is borrowed from our own city of Sacramento, where we are located today. To the original people of this land, the Nisenan people, the Southern Maidu, Valley and Plains Miwok, Patwin Wintun peoples, and the people of the Wilton Rancheria, Sacramento's only federally recognized tribe. May we acknowledge and honor the Native people who came before us and still walk beside us today on these ancestral lands by choosing to gather together today in the active practice of acknowledgement and appreciation for Sacramento's Indigenous peoples' history, contributions, and lives. When I was looking at various ways to honor Indigenous Peoples Day and bring awareness, I had been familiar with the land acknowledgement tradition that has been recently more broadly adopted, including by many local governments, not just here in California, but in other states and jurisdictions. And there is a resource if you wish to see which indigenous peoples were based on your land, and I'm going to ask Santiago to include that resource in the chat. They do acknowledge that it's a work in progress and built on the contributions of many people, so it's not necessarily objective fact, but it is a great resource if, depending on where you're located, you want to see what other peoples have been on the land that we now have the privilege of being able to occupy. And with that, I will turn it over to our General Counsel, Julie Montgomery, to give her recommendation on the restructuring of the regions, and turn it over to her.
Picked up. I don't hear the interpreter.
Take it and just hold it like
We
that?
could try,
Or is it
yeah.
not on?
I don't know if it's on.
Hello, Ted. Oh, there it is. Okay. So I'll just start over again. Good morning, everyone. Good to see everybody here in person and online. So I am going to just reiterate a few points that I raised in a memo that I previously provided to the board as to why I am proposing to restructure our regional offices. So in essence, the main purpose of this proposal is to better balance the supervision of attorneys between the two regional directors. That is the primary purpose. Right now, our Salinas Regional Director supervises more than twice the number of attorneys as our Visalia Regional Director does. And so in looking to correct that imbalance, we did look at our sub-regional offices. So we have two main regional offices, of course, and then the three sub-regions. And right now, our Salinas Regional Office has Santa Rosa and Oxnard as sub-regions that it oversees. And then in Visalia, we have the one sub-regional office of Indio. And so in looking at how to rebalance the supervision, we looked at our two medium-sized sub-regional offices, which are Oxnard and Santa Rosa. And so we examined the possibility of moving either Oxnard over to the Visalia region or Santa Rosa. And for a variety of reasons, we landed on Santa Rosa. And one big reason is that the strawberry industry spans between Oxnard, Santa Maria, and Salinas. And of course, that is a huge industry in California. And our regional director, as well as the staff in Salinas, does develop expertise in the commodities of the cases that they see. And we do get a large percentage of cases every year in the strawberry industry in these areas. It's a huge industry, right, for our state. In addition, workers migrate between or among these three areas, and so there are some similarities in the workers that show up at our various sub-regional offices. So we thought it would make more sense to keep those offices in one region with the one regional director and the staff that is most accustomed to handling those cases. By contrast, the Santa Rosa office sees mostly wine grape cases or cases in that industry. And of course, there are also a lot of wine grapes in the Central Valley, which is in the Visalia region. And in addition, we know that there are a number of dairies up north as well. And although we haven't seen a whole lot of those cases, we know they're there. And of course, the Central Valley is a huge dairy producing region as well. So looking at the similarity of commodities, we thought it made more sense to have Santa Rosa be part of the Visalia region instead of Oxnard. And an additional reason for including Santa Rosa is that it's located fairly close to Sacramento, and we do have two Visalia region staff members placed in Sacramento. We have a field examiner and an attorney who do work out of Sacramento, and part of their work is to help conduct outreach and education to the community and to our stakeholders in the Northern Central Valley and the Northern California region. And given that Santa Rosa is also in the northern part of the state, we thought it would make more sense for collaborative purposes for outreach to have them in one region. And in fact, our outreach specialist who covers the Visalia, or who's out of the Visalia office, actually did voice support for Santa Rosa being included in the region. And she said that she thought that would also help her work, so that our staff can a little more closely collaborate with one another. So those are the primary reasons for wanting and needing to restructure the regions and move Santa Rosa over to the Visalia region from the Salinas region. So I don't know if there are any questions, but I'm happy to answer any as I can.
I'll look to my colleagues. Do any of my colleagues have any questions? Okay, I do want to acknowledge the General Counsel has been really working hard on this, and also just kind of thinking overall how to best support the program and the needs of the staff. And I know it's been a challenge with a lot of different factors, and really commend your work, and also appreciate that you've consulted, I know, staff as well and sought staff input. And so I know it's been a really challenging puzzle, and I think it's a great solution, and appreciate your work on this.
Thank you so much. And I also just want to mention there's some proposals to centralize our case numbering and also change the name of the regions from being place-based to just numbered regions. And I think with our current technology, that it's very easy to track what cases are filed where and numbers of cases. And so having the suffix of SAL or VIS at the end of a case, I think we should drop that. And then at a glance, you can also just see, okay, there's been so many cases, this is number 37, CE 37, that means there's been 37 cases filed this year, or whatever it is. So I just think it'll be simplified if we also change that numbering system. So I wanted to mention that's also in the proposal. So thank you very much.
I agree. I will entertain a motion to approve the General Counsel's recommendation to restructure the regions as detailed and change the case numbering system.
I'll make the motion.
Okay, and seconded by Member Flores. All those in favor say aye.
Aye.
Aye. Restructuring approved. Thank you so much.
Thank you so much.
Thank you.
Okay, our next agenda item is the Executive Secretary's report with Santiago Villagomez. Santiago?
Thank you, and good morning, Chair Hassida and members of the board. For today's report, there's matters that have had an action or since the last public board meeting on September 6th. So in that time frame, there's been 2 complaints settled. The first being Sonoma Cho, doing business as Flora Terra. And I was remiss in mentioning that this report and all other reports are listed on our website under the meetings tab. So going on, returning Sonoma Cho, a settlement was reached on September 22nd. The next matter is Linda Christie, doing business as Sunny Knoll Vineyards and Christie Vineyards, and that was settled on September 7th. Moving on to administrative orders issued by the board, it's the admin order 2023-09 that was issued on September 11th in Ocean Mist Farms, and it was an order denying the respondent's motion to reconsider and or modify the board's previous admin order. And that involves the board's decision in 46 ALRB number 5. Finally turning to pending matters is the National Agricultural Workers Union, NAWU, and that case number is 2023 LPA 002, and the General Counsel issued her report and recommendation on September 21st, responding to the complaint that was filed in July. That concludes my report. Happy to answer any questions.
Thank you, Santiago. Our next agenda item is the litigation report. We do not have a report today, and so we will turn it back to our General Counsel for her report.
Okay, I guess I could have just did it. So I'm going to report on two settlements that we achieved in the past month. And I think one of them was executed later in the day after our meeting that we had last month. So I didn't get a chance to highlight it. And that one is a settlement involving 3H Custom Farming. And in that case, the Mixteco Indígena Community Organizing Project, MICOP, filed a charge on behalf of butternut squash harvesters in Ventura County, alleging that 3H Custom Farming retaliated and discriminated against workers by harassing them, changing their work conditions, and creating a hostile work environment because they engaged in protected activity, and that this ultimately caused them to resign. And the workers claimed that they complained about dirty restrooms, quality and availability of drinking water, unsafe work conditions, and limited shade during hot weather. And the ALRB filed a complaint on June 30th of this year. And in this case, too, I'll just mention that the harassment mentioned included derogatory comments against Indigenous workers, calling them names that were very derogatory based on their ancestry. So that was just a concern. But we filed a complaint on June 30th, and the parties entered into a settlement agreement on September 6th, in which 3H Custom Harvesting agreed to pay $17,505 in lost wages, and also agreed to reinstate the two workers to file the complaint, and then of course also agreed to the standard noticing remedies. And then the second settlement, which our executive secretary mentioned, involved Sonoma Cho, which is a cannabis operation. And in that case, the Teamsters filed a charge against that company in Sonoma County in November of 2022, alleging that Sonoma Cho had announced unilateral changes in employees' wages and working conditions without giving notice to the union or offering to bargain with the union about the changes. And another charge was filed by one of the cannabis trimmers, claiming that the company retaliated against him and others by reducing their piece rate in retaliation for participating in union activity and in prior ALRB investigations. So we did file a complaint also on June 30th against that company, and entered into a settlement agreement on September 22nd. And that agreement states that Sonoma Cho will pay $11,900 in lost wages to the two workers who were adversely affected by the unilateral piece rate change. And they also agreed to reinstate the prior piece rate for 42 days while the Teamsters and Sonoma Cho bargain over the piece rate. And Sonoma Cho agreed to participate in at least 4 bargaining sessions with the Teamsters within 42 days from the execution of the settlement agreement. And then they also agreed to the standard remedies. So those are the two settlements I have to report. And then we've also been very active in conducting outreach and trainings. We've done various presentations to different groups. I won't detail them all here, but we've been in Salinas and Watsonville, Monterey County. We did a virtual training for staff of the Central California Environmental Network. We've also been at 13 community events all over the state: Indio, Salinas, Madera, Oxnard, attended Guelaguetza, Indigenous culture celebrations in Fresno and Lamont in Kern County. We had staff in Soledad and Monterey County, Watsonville and Santa Cruz County, Salinas. We had someone go up to Tule Lake, which is in Siskiyou County, the Oregon border, very far to travel, so appreciate that. And also in Indio. And then we've also been on radio and TV and Facebook Live. I appeared on September 7th on a Univision program called Despierta Valle Central, hosted by Lucita Lomelí. We also had staff on Radio Indígena and Oxnard, both in Spanish and Mixteco, Spanish and Sriki radio interview called La Hora Tiki, hosted by Radio Bilingüe, which broadcasts to Central Coast areas, and also Radio Bilingüe's Comunidad Alerta, which broadcasts all over the state, and in addition to other states like Arizona, Colorado, New Mexico, and Texas. So we're trying to get the word out about who we are and what resources are available to folks, and staff has been busy. So any questions?
I don't have any questions, but wonderful report. Thank you. I don't think any of my colleagues. All right.
Thank you.
Appreciate it. Okay, our next agenda item is a report from our Chief of Administrative Services, Brian Darity. Brian?
Good morning. I have just a couple of brief updates. Happy to announce that we have completed all of our budget change proposals for review as part of the proposed 2024-2025 governor's budget. Those proposals are currently under review within the administration, so working closely to try to advocate to get those approved. In addition, on the administrative front, we have been notified that we have two regularly scheduled hearing compliance audits that are being scheduled. One on our IT policies that is going to be conducted by the Department of Technology. They're supposed to engage ALRB starting next week, and we were just notified on Monday that the State Personnel Board will be doing their biannual compliance review of all of our HR practices as well. So we expect to begin engagement in the month of October with the State Personnel Board staff on that as well. I am also happy to announce that we have filled our opening for our staff services manager one in an administration unit. This the position that's over our fiscal and procurement and facility operations. We've had Dalton Weber, who's been working out of class and filling in since Jan Shores left in April, and I'm happy to announce that we permanently have offered that position to Dalton effective today, and he is accepted. So Dalton will be is looking forward to his new role here at ALRB, and I wish everybody can reach out to him and appreciate all of his hard work over the coming months in this new role.
Thank you, Brian, and also congratulations to Dalton. We're so appreciative of all the work he's done, and excited to see him continue to grow in this new role. So, great work. That concludes the Administrative Services Report. Our next agenda item is legislation, which we'll have with Chief Board Counsel Todd Ratchin, and then from there we'll also have the regulations report. Todd?
Okay. Wait, is this thing still on?
I think you have to.
For the legislative report, very short report, there's a report available on the website as well on the meeting page. On September 22nd, the governor signed Senate Bill 544. This had Bagley-Keene Open Meeting Act reform to make permanent certain provisions regarding teleconference meetings.
Permanent until 2026.
At least until then.
All right. Thank you, Todd. And the regulations report.
Okay.
I think you're going to
yeah,
you want to stay up there for a
okay,
little bit.
Yeah, sorry. So we have two reports today. I believe Member Broad will present the report on the cannabis and LPA implementing regs from AB 195, and then the subcommittee has asked me to prepare or to present the AB 113 implementing regs after that.
Good morning. The way we were sort of hoping to proceed is that we'll do each of the two packages. Todd will make we'll introduce him. Todd will make detailed comments. Then we thought with your approval, then you would take comments from board members, followed by any public comment on each of them.
Sure.
Okay. So, good morning, everyone. We have two proposals. The first, AB 195, deals with labor peace agreements in the cannabis industry. This is a request for final approval of the regulations. What is before us today are technical, purely technical amendments that were a consequence of discussion with the Office of Administrative Law, and they're very minor and technical, as I mentioned. Todd, do you have any specific discussion of them you want to mention?
Yeah, just briefly, the two real changes related to a couple filing deadlines that are set forth in the proposed regulations for when certain types of filings would be due, and just specifying whether those would be due within 5 days after service of a document or 5 days after filing of the document. So that's the changes are of that nature.
Okay, so we're done.
Okay. I don't have any questions. Do any of my colleagues have any questions on that proposal? Any questions from the public or anyone else on that, on the cannabis regulatory proposal? Okay. I'll move to approve the regulations go forward as recommended by the subcommittee. Can I have a second?
Second.
All right. All those in favor say aye.
Aye.
Wonderful. Okay. All right. On to a blockbuster reg package for AB 113.
Yeah, so this regulation package is a new regulation package implementing AB 113, which was the legislation that modified legislation last year to establish our new system for majority support. I guess, well, let's call it card check, a card check system for determining majority support in union organizing campaigns. The subcommittee held a workshop for interested members of the public that was well attended, and we had a spirited discussion, which was, I would characterize as very helpful to the subcommittee in understanding the positions of the parties and issues that might arise. And we tried in revising our original proposal to address some of those. I'll ask Todd to go over these in detail, and then we can get into the discussion.
All right, thank you, Barry. I won't be going into too much detail. The proposal that the subcommittee released last week is in a red line format to indicate the changes from the original proposal several months ago. And so it's been, much of this has been out in the public domain for a few months now. And so, there will probably be, I'll try to focus a bit more on, some of the changes that have been made and then reflected in the red line. Just a brief overview, 30,000-foot view of how this process would work, at least in terms of the majority support petition and new Labor Code 1156.37. And then I'll also touch briefly on the revisions to the compliance regulations and the new statutory provisions on appeal bonds, and then turn it back to the board and the public for comment and questions. So in terms of the majority support petition process, Subdivision A, well, I will say again that the statute is pretty detailed in a lot of the procedures on how this process works. So a lot of the regulation is in the nature of gap filling, where possible and where we believe it makes sense. We borrowed from existing procedures, for instance, Regulation 20300 in terms of procedures governing the investigation and review of petitions for certification. So a lot of the language is borrowed from those regulations. Subdivision A, under proposed section 20391, really governs the filing and service requirements for majority support petitions. Subdivision A1 focuses on the requirements and the content of petitions or authorization cards. This was a topic of some discussion at the public workshop at the end of June, and some of the comments the board received regarding whether to adopt procedures to allow for the revocation of signatures or expressions of support, or language clarifying on the cards themselves that an expression of support on a card is the equivalent of a vote in an election that would not be revocable during the one-year time period from the date of signature. And so the procedure proposed here would be adding that type of language to the card, that it is in the nature of a vote in favor of the union that is valid for 1 year and not revocable within that time frame. Subdivisions B and C govern the regional directors and the regional offices review of a petition in terms of unit determinations and other questions regarding whether a bona fide question of representation exists. Subdivisions C2 and 3 would relate to more in the nature of the determination of the proof of support and whether majority support has been established. If on the first review of the petition and the support received, the amount of cards or signatures received is insufficient, doesn't meet the majority threshold, then under statute, it's returned to the labor organization for 30 days to cure invalid cards or to obtain additional support. And so at the end of that period, at the end of the card count, whether support is established or not, the proposal here would have the regional director prepare something in the nature of what the board sees when a secret ballot election has been conducted, and so a sort of tally to indicate what the final count came out at. Those are some of the new changes that were added since the original proposal. From there, subdivision D governs the objections process that is briefly laid out in statute if a labor organization is certified following the count. The following subdivisions relate to instances where a second majority support petition may be filed while a first is being processed. Under statute, generally, the second petition would be barred unless it contains certain types of allegations in the nature that the labor organization has been created or assisted by the employer. And then there is a provision in here, I think it is in E2, which relates to, moving down to subdivision G, a procedure for consolidating objections with pending unfair labor practice charges that may be on file with the General Counsel's office. This is borrowed largely from existing law for consolidating those types of allegations. And the context of a typical petition for certification. And then the final subdivision in this section, the statute 1156.37 has a couple provisions regarding employer misconduct that occurs during a time that a majority support petition campaign is underway. So the final subdivision of this regulation would provide some guidance in terms of those statutory provisions establishing a 10% threshold that if a labor organization is able to demonstrate support of at least 10% of the employees, that would be sufficient for purposes of those statutory provisions for saying that a campaign was underway to trigger the consequences of, the types of employer misconduct that is defined in those statutes. Then there's been some pretty significant overhaul of the compliance regulations. A lot of it is mainly the numbering and the reorganization of the compliance sections of our current regulations. And this is in order to comply with the new requirements under the new statutory amendments to our act, where a monetary remedy has been ordered by the board after making an unfair labor practice finding. The decision is not final for purposes of 1160.8 judicial review, but rather is referred directly back into compliance proceedings for determination of the amount of the monetary remedy owed. And then at the conclusion of that process, once the monetary remedy is specified, that would set the amount of an appeal bond that an employer would be required to pay or to post as a bond in order to seek judicial review of the entire proceedings of both the liability and then any issues that arose during the compliance proceedings. And so this is a pretty significant change from existing law where compliance proceedings typically would occur following judicial review and finality of those proceedings. So a lot of this is really a lot of the original proposal from June remains intact. There were some questions received during the public workshop at the end of June just regarding the mechanics of the bonding procedures and how the board would handle the bonds or cash deposits it received. And so there are a few new sections in red line towards the end of this proposal regarding the bonds that would be required in unfair labor practice or mandatory mediation and conciliation proceedings. And a lot of this is taken from just the Code of Civil Procedure, bond and undertaking law, that chapter. And so it's, basically, the sections that these procedures are drawn from are all listed in the reference notes at the bottom of this regulation. So I'm sure everybody is eager with their questions and comments, so I'll turn it back to you.
Thank you. And before we open it up for questions, I just want to remind everyone, board members, staff, and members of the public, we do have one pending majority support petition that's in a cure period right now, and we just need to be mindful to, we should not be discussing any pending matters or alluding to any pending matters, and the board cannot resolve any questions about or accept any ex parte communications related to that. So with that, I will open up the floor. I don't know if any of my colleagues have any questions. I had one question, some that I went over with Todd yesterday, but one on proposed section 20290. This is one of the appeal bond, 20290D. So it states, if a respondent fails to file an answer within the time prescribed by this section, the administrative law judge may, either with or without taking evidence in support of the allegations and without notice to the respondent, find the allegations of the specification or the notice of hearing I just was unclear about the without notice to the respondent. I think even in rereading it, I may have resolved it. So is this that the ALJ doesn't have to give additional notice, or what? I just want to make sure I'm understanding the without notice to the respondent. I don't disagree that there should be sanctions if someone fails to respond, but the notice part, I just want to check.
So this section, the subdivision D, is modeled after current regulation 20292C.
Okay.
A lot of the language is taken from that. So that's something that can certainly take a look back on. I would imagine consistent with when the board sees a default case in an unfair labor practice matter on a liability issue where a respondent has not answered within the time we're doing so. There typically is a motion for entry of default and to see the allegations admitted. And so I'd imagine it would follow that type of procedure that, you know, the respondent would be notified one way or another.
Okay. That was one of my only outstanding questions.
I just wanted to make a comment before, so maybe a point of clarification. So, generally speaking, I want to really appreciate the work of the subcommittee. I think, this draft is, very robust, and in particular, I know you noted, Todd, subdivision A1, I really appreciate the detailed additions to what would constitute an actual signing of the card and what that means. And I think we've all done a very good job of clearly communicating to folks that I know that was a topic of discussion previously. And similarly with the appeals bond section, I think it goes very into detail and pretty clear. I did have just a general question for cash or cash equivalent deposits. It's noted in section B3 that the deposits will be entrusted to the board in an interest-bearing account. Generally speaking, the decision to hold it in an interest-bearing account, is that just a consequence of the type of account that's available, or is that a specific, or is there a specific reason for holding it in an interest-bearing account?
That's a provision of statute in the bond and undertaking law where a cash deposit is made in lieu of an appeal bond that the officer, here would be the board, would be required to hold that money in trust in an interest-bearing account. It's all set forth in statute. And then interest that accrues on the principal would be payable back to the employer who made the deposit on a quarterly basis if they so desired, if they requested that.
Thank you.
Yes.
Thank you. We do have various members of the general counsel staff and regional director staff here. Do we have any comments from our staff in the room on the proposed regulations?
I have a short question, technicality.
Can I ask you to just go up there, just so then the folks on the Zoom can hear you as well?
I'm not going far.
On 20391A, it says a petition shall be filed electronically. That's after the red line strike through. But the cards have to be delivered in person. So I'm wondering why we're requiring electronic filing in addition to the physical delivery of cards, and whether a petition could be physically delivered instead of electronically filed.
Thank you.
I read that it can be filed by, okay, it has two different things. All right, I see it now.
It is, yes, in some of the language here, in terms of electric filing, is influenced by the new regulations that just took effect on the 1st of this month, which require electronic filing as a general rule by represented parties. I mean, we're in pre-rule making now. If a different, process makes sense, I mean, that's certainly something that the board can consider here. I do recognize, a bit of inconsistency in requiring the petition itself to be electronically filed, but, we do have to accommodate, in addition to that, the actual delivery of the support to the appropriate regional office.
Yeah, let me add to that our thinking there on this particular subject emanates from the general view of the subcommittee that these cards are akin to ballots in an election, and that if there are to be objections that or questions related to the cards themselves, the process in which they were gathered, or whether they're real or whatever someone could invent as or allege, I shouldn't say invent, allege as an objection, that the board is going to need the original documents anyway, just as in an election you need the ballots. I do think you may be raising a good question about whether we need to do both or just say deliver the cards. So that's a good question, and one that we might consider as the process moves forward. But I think we do believe in any event, minimally, the original cards need to be delivered to the board.
Member Lightstone?
Yeah, I would just like to ask Francesca a question about her comment, which is, are you saying that you would, given your experience, you would prefer that that the petition itself be done on paper?
I think we should allow for the possibility that someone could just deliver it in paper and not add an additional layer of bureaucracy requiring electronic delivery and then the physical delivery. That's all.
Thank you.
Okay. Any other comments from our staff in the room? Okay, we'll open up the comment queue. I believe we have at least one member of the public. Carl Borden from the California Farm Bureau is first up. Carl?
Thank you, Chairperson Sid. I am Carl Borden, Senior Counsel with California Farm Bureau Federation, located in Sacramento, and we promote the interests of the state's agriculturalists, farmers, and ranchers. I did participate in the June 23rd public workshop, followed up a week later by submitting written comments reflecting what I said during the public workshop. And so I will be brief here, because what I will say, Rita, I don't know if you've had an opportunity to see my written remarks, and also I do understand that California Farm Bureau will have an opportunity to comment once the rulemaking package is formally released. So there's 2 points I'd like to make, both of which go to provisions in proposed 20391A1. And the first is that in the newly added language, a signature on the card or petition is valid for 1 year from the date it is signed. In my oral and written comments, I had said that given the fact that there is a 30-day grace period offered to a union that was unable on the submission of the petition to prove employee majority support, to gather and submit to the board additional signatures. And so what that means is that there might be instances where cards that were or petitions that were signed early on that could then become essentially stale and exceed that 1 year limit of validity. And So even though they were valid at the time the majority support petition was filed, the clock continues to tick and they could become invalid because they would be more than a year old at the time the determination is ultimately made after that 30-day additional grace period is offered to the union. And in fact, the addition of this language conflicts with the initially proposed language that's in A2, where it says no employee authorization dated more than 1 year prior to the date of filing of the petition shall be counted to determine a showing of majority support. I think that creates a conflict between these two provisions. I had, excuse me, in my written remarks, suggested an alternative, in that rather than following in lockstep the existing provision for showing majority support for a secret ballot election, that it should read no employee authorization dated more than 1 year prior to the date of the determination of majority support shall be counted to determine a showing of majority support. But again, I will reiterate that in subsequent comments that we will file. Secondly, the question of the employee's right to revoke an authorization previously given. I had urged that ALRB regulations reflect what I consider to be applicable NLRB precedent as required by Labor Code Section 1148, that employees under NLRB case law do have the right to revoke their authorizations previously given to a union. The initial draft that I was commenting on was silent in that regard, and I see now that instead of heading the direction that I had suggested, the regulation goes the opposite way and says that a signature given is not revocable during that 1 year period because, as I heard it expressed earlier in this meeting, that is considered a vote. Well, it's really a conditional vote. It doesn't become a vote until the time that the majority support petition is filed, and then ultimately a determination is made. And as I expressed in the written comments, it's a different situation when we're talking about this conditional vote becoming an actual vote versus an employee signing an authorization card that could be used by a union to call for a secret ballot election. Because in the latter situation where it's being used to call for a secret ballot election, the employee's real-time expression of sentiment towards unionization will become manifest during the secret ballot election. So even if the employee gave many months before the secret ballot election an authorization card that calls for a secret ballot election and supports one, the employee will then be able to express his or her or their real-time sentiment. But this is a different situation where you have the employee signing an authorization card perhaps many months before the union files its majority support petition, during which time the employee may have changed jobs. There could be different situation with the employer that employee now no longer feels a need to have a third-party union get between the employee and the employee's employer. Even at the time of when the union authorization card was filed, the employee might not have been an employee of anyone. As an aside, it also, even though this is put in there that it's not revocable, it doesn't deal with a situation where the employee, after signing one union authorization card, signs one or more other union authorization cards authorizing one or more other unions. It's conceivable that you could have, well, I guess under, I'll take that back. I was going to say you could have um, uh, a situation like in the secret ballot election process where you have two or more unions vying to recognize to represent the same bargaining unit. But I realize now that the structure of this is it's really one union at a time. So I won't. I'll withdraw what I was going to say. So anyway, I hope that the agency will reconsider its position in this regard and follow again, the applicable NLRA precedent. Thank you very much. And by the way, that applicable precedent, as I cited in my letter, is Bluegrass Industries, Inc. It's a 1987 NLRB decision, a 287 NLRB number 28. And yeah, okay, thank you.
Oh, sorry. No, that's on our end.
Wait, so can I talk?
Yes,
Okay.
yes, sorry.
You have to restart.
I'm sure people don't want to. Okay, so I'll just start over. This is pre-rulemaking, so there will be future opportunities for comment regardless of any action taken today, whether revisions are requested or when it does eventually proceed to formal rulemaking through the Office of Administrative Law, there will be future opportunities for comment. And written comments that were received following the workshop in June, those are available on our website on our rulemaking page as well. I will just briefly, for the board, touch on the two issues raised. In terms of revocation rights, there is NLRB precedent regarding employee rights to revoke a prior authorization given or support expressed, and what the requirements would be for that, exactly how you would express your desire to revoke a prior authorization. Now, whether that's an inherent right of the employees, I don't think that those cases necessarily establish that. There is Public Employment Relations Board precedent regarding revocations where a representation petition has been filed, and there was one PERB order where neither the statute or the regulations provided for revocation rights, that revocations that were produced in an effort to defeat a petition were disregarded by the board because they were not authorized by the statute or regulation. And then in terms of signature validity for the 1 year time period, I see the language of 1 and 2. I don't necessarily believe those operate inconsistently or present a contradiction or conflict with one another. I think for purposes of predictability and adding some certainty to the process, that when a filing is made, if a signature in a support, whether it's a card or a signature on petition, if that was valid at the time of filing and the time it is initially counted by the regional director, I think it would just offer just some awkwardness, some unpredictability if you kept everything in flux, so that cards that were valid later become invalid during the subsequent cure period, because there's no subsequent cure period allowed beyond the 30 days for those situations. And so, I think it is feasible and workable that, a card that is valid at the time the petition is filed, it offers that predictability that the parties all know the ground rules, and, cards that are valid then are going to remain part of the count. and they're not going to be lost when the labor organization, if it is in a cure period, subsequently produces additional support.
One question I had, because I've heard some of these arguments, and I think one of the things that I appreciate that the regulation does, it says regardless if there's a time period, whether you offer a right to revoke or not, it needs to be clear that whoever is signing a card is informed, and I think this regulation gets to that. Going to Mr. Borden's point, one of his points, if an employee signs a card, say in 2020, August 2023, the cards are submitted in June 2024, that's when you get the employee list, and that employee is no longer employed with that employer, would that card count towards majority support?
I don't believe it would under existing law, in a petition for certification context, because there is a requirement, and it is spelled out in one of the provisions here, that, a card can be signed at any time. But I think, for purposes of determining eligibility, that employee for their card, if they did sign a card, for that to be counted towards the proof of support, they must be on the payroll for the preceding pay period.
Got it.
For the filing of the petition. So, that employment requirement remains.
Okay, that's helpful. Barry?
Yeah, I wanted to discuss, at least from my perspective, about a revocation. The ALRB under this statute or ALRA under the statute is substantially different from the NLRA. Very, very different. And the statute is completely silent about whether there can be revocation. And I don't believe, under basic rules of statutory construction, that silence can be inferred as authority for the ALRB to establish a process that isn't available under the statute. And if you think about it, when you start talking about revoking something, you would need, and I believe the legislature would have to provide that and think through it, a whole process for revocation. When revocation is valid, how long revocation is valid for? Can an employee sign a blanket revocation? All of these are questions which we would just have to make up an answer for. And I think if the legislature had intended to provide for revocation of these cards, it would have put it in the statute. And so I don't believe we have the legal authority, whether it's a good policy idea or not. I don't think we have the legal authority to adopt that, and that if that's a problem out there for folks, they need to amend the statute.
I see that Mr. Borden has raised his hand.
Very briefly, in response to Member Broad's comment, I think the same thing could be said for the fact that the statute is silent as to having in the regulation a prohibition against revocation.
Okay. I see Matthew Allen's hand is up.
Good morning, Matthew Allen with Western Growers Association. I appreciate the opportunity to speak this morning. I would concur with all the comments that Carl has made with the California Farm Bureau, especially as it regards the issue of revocation of the cards. I think there's some understanding that up to a point, the petition being filed, that's sort of a different narrative about the potential to revoke that authorization. But up to that point, it seems to be just a fundamental fairness issue. It strikes me as that. And I agree with Carl's last point that if the statute is silent on it, this seems to go further than what's currently in the act. So this piece of it is concerning for us.
Noted. Are there any other people in the comment queue wishing to make a comment?
Not at this time.
Okay, give a moment here to see if anyone else wishes to comment on the regulatory package. And do any of my colleagues? Okay. With that, then, I will make a motion to move the proposed regulations as recommended by the subcommittee for AB 113 forward and prepare a package for formal rulemaking. Can I have a second?
Second?
Thank you, Member Broad. All those in favor?
Aye.
Aye. All right. Thank you. And we'll providing more information once we enter formal rulemaking.
Thank you.
Okay. And now, prior to going into closed session, the board will open it up for general public comment. Please state your name and organization if applicable, and you can either raise your hand or make a note in the chat feature, and we will take comments in order received. Okay, not seeing anyone that wishes to make a comment, the board will now gavel into closed session. Thank you. Okay, the board is now returned from closed session at 11:39 a.m. Our last agenda item is announcements. We will have our regional directors meeting at 2 p.m. today, and the agenda is posted on our website. If you would like the dial-in information, it will be virtual. And then our next regular public board meeting is scheduled for Wednesday, October 18th. Thank you. This meeting is now adjourned.